for the 5th District of the State of Florida is now in session. The Honorable F. Ray Wallace, Judge, presiding. All persons having business before the court, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, they have forever.
Was that all the time? I haven't listened for 10 years.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. We have one case on the docket this morning. It is Breed versus State of Florida. But before I get to that, I want to welcome from Atlantic High School, Ms. Rivera's class. I believe this is a Criminal Justice Academy. All right, welcome. And we are here for the case of Breed versus State of Florida. I would just ask that anyone who is in the courtroom that has a device that may make noise, please put that on silent, or better yet, probably just power it down. On the panel joining me, I've already been introduced. To my right and your left is Judge Brian Lambert from Marion County, and to my left and your right is Judge John Harris from Brevard County. After the OA, since this is part of the law day time of year here for the court, I'm going to ask the attorneys if after they're finished with their arguments, we'll open it up and allow you to introduce yourself to the students. The students are welcome and encouraged, and the teachers and any parents here are welcome and encouraged to ask any questions. We as the panel will not comment on the actual facts of the case or what will happen with the case, but I'd invite the attorneys specifically to kind of give the students the benefit of their background and how you came to the profession that you're practicing in right now so very well. We see a lot of briefing from the parties involved and the attorneys involved. So with that being said, I'm going to assume, Mr. Ufferman, that you would like 5 minutes of rebuttal unless you tell me otherwise.
That's correct.
And then you may proceed.
Good morning.
Good morning.
May it please the court. Michael Ufferman on behalf of the appellant, DeAndre Breed. I'm hoping to focus my time this morning on the first claim raised in the briefs, and that is whether the trial court erred by failing to give the requested curative instruction after the trial court itself objected to defense counsel's closing argument. I think this is a pretty straightforward issue. I don't think there's any dispute in the record that an error occurred. If you read the transcript on page 928.
When you say error, you mean he misspoke?
Yes.
He should have said sustained instead of objection.
There's maybe a timing issue there too, because the way it reads in the transcript and the way defense counsel explained it on the record is after he made the argument that was potentially objectionable, it was the prosecutor, the transcript says the prosecutor stands up, and then the court says objection sustained, and only at that point, after both of those are said by the judge, does the prosecutor then say objection, Your Honor, and then the court immediately says, come over here, please, and the parties went to sidebar.
Well, it would have been worse if the judge overruled his objection, right?
It would have been interesting. The other important point to make about this, I think defense counsel made a very clear record, and to the judge's credit, I think he acknowledged what defense counsel was saying. Defense counsel said that it was said in a very passionate and very loud voice, but the judge himself said, quote, I yelled objection. I yelled objection. So error occurred here. And again, you said misspoke. I don't disagree with that. I clearly from this.
He wasn't planning on objecting. I mean,
correct.
This is an experienced judge. I don't think he thinks he's involved in the objection process.
I don't disagree with that. Now, the only thing I would say is a little bit of background. This was a pretty contentious trial and a lot of back and forth between defense counsel and the judge in this case. Clearly, the judge was getting upset with defense counsel, and I would submit the judge let that get the best of him. Maybe not necessarily that would have caused, I mean, he did yell it. He yelled objection and then sustained. Maybe that's building up in the judge. But more importantly, clearly that's I submit, what caused the judge to ultimately not give the relief that was requested, which is the only relief that could be given, and it's consistent with the law. Why not give the curative instruction?
I agree with you there. I did not understand the hesitancy of the trial judge, not just to say to the jury, my bad, I misspoke, I'm not the objector, I saw the prosecutor standing up, and I knew the prosecutor was going to say objection, I just anticipated too quickly, and I should have waited, and I didn't get what the hesitancy was, why the trial judge would just simply say, my bad, I made a mistake, I'm not the I don't do the objections, that's what those guys do.
Perfect.
Yeah, I didn't get that, I don't understand it either. But.
And I'm not perfect, I make mistakes. I know that all three of you were trial judges. I'm not saying you would ever do this, but I submit that if whatever mistake might be made in terms of misspeaking to the jury, the way you correct that is simply say, my bad, I misspoke. Just what you said. I couldn't say it better than what you just said, Your Honor. So in these situations, you almost imagine, and you've read it, I've read it in hundreds of records, you have too, you presided over trials where this occurred. The defense attorney's first words are mistrial. And the judge usually then says, okay, this doesn't rise to the level of a mistrial, but I am willing to give a curative instruction. And that happens over and over again. And, you know, sometimes the defense attorney takes up the judge on that request, sometimes the defense attorney does not. But I mean, you can't imagine a situation, it's hard to imagine, and I've argued that there is no situation that would be reasonable where if that is what occurred, the defense attorney is saying mistrial, nope, but I'll give you a curative instruction. I can't imagine a judge who wouldn't have followed up, I deny your request for a mistrial, but I'll give you the curative instruction. And that didn't happen here, and yet defense counsel's only request was for the curative instruction. And it was a curative instruction that was clearly consistent with the law. The request that he was making was simply, to quote, ignore the trial judge's objection to defense counsel's closing argument, and anything I say or do, I don't favor one party. So the judge, a couple other points to make about this. I mean, the judge seemed, again, to base the denial of the request for a curative instruction on the fact that defense counsel made an improper argument. That's not the basis to deny the curative instruction. And you see that at the end of the argument. And this went on for a while. He said, this wouldn't be an issue had you not made the improper argument. Again, I'm not here to defend the argument. I'm not arguing that the sustaining of his own objection was correct. I'm not going to defend defense counsel's potential Brady argument that shouldn't be made to the jury, but attorneys step out of bounds sometimes, and it's for the other party to object, and it's for the judge to rule on that objection. But here's the problem. We know, and you know, I've cited numerous cases, but the best case is really the Johnson case from this court, and this is what the court said. The requirement of judicial impartiality is at the core of our system of criminal justice. The judge must above all be neutral, and his neutrality should be of the tough variety that will not bend or break under stress. There's stress going on in this trial, and I think the judge let it get the best of him. This court went on to say, the judge should not lean to the prosecution or defense lest it appear that his neutrality is departing from center. A trial judge who assumes the role of prosecutor deprives the defendant of due process. And that's what happened here. Defense counsel, again, this is preserved very well by defense counsel. Defense counsel says, page 942, everything I do from here on out until they get that instruction will be with the taint of them believing that somehow the court chastised me and sua sponte objected to something. Page 928, 929. The jurors, unless there is a curative, will get the impression that the court favors the prosecution. And this was prejudicial. This occurred over at least a 15-minute period. After they went to sidebar, the judge directed them to go to sidebar. After the judge yelled, objection sustained, they argued for a little bit, and then the judge calls the jury back in and says, we're going to take a 15-minute break. What is the jury wondering? When clearly the jury just heard the judge yell objection to the defense attorney's argument, and then when they come back, all that said is defense counsel is going to continue with his argument. So,
well, leading up to that time, had there been, I know that the sense was the judge was getting a little weary of the defense counsel's presentation, I'll say it that way, presentation throughout the course of the trial, but I don't recall, had there been motions for mistrial before? I know this was not a motion for mistrial, no. But in other words, there wasn't something going on leading up, the defense counsel's pointing out to the judge, maybe unsuccessfully, saying, this seems like the trial's getting a little bit slanted against me here. It's not fair. So, they've gone along. They go to the closing argument, And, you know, some attorneys have different presentation styles than others, and some judges are more patient about things. And I'm not picking on the judge per se here.
Understand.
We all have our days.
Yes, exactly.
But, you know, so basically, this is the point of, okay, here's a scenario that you have crossed the line, and as you point out, he didn't ask for a mistrial, which, you know, maybe in hindsight, if he had asked for mistrial, the judge would have given him a curative instruction.
Right. No, that's right. That's why I'm making that point. Exactly. So no, you know, I have to rely upon what defense counsel said. I think you can look at the record and see that there was tension building. But nevertheless, when the judge said, I've been completely fair, defense counsel responds and says, you have been up until this moment. So, you know, I think it was building, but did defense counsel make motions at other points? No.
There have been other cautionary instructions on the record. Is that correct? Has the judge instructed? I mean, I know they had sidebars where the judge had to instruct the attorneys to keep their voice down because
Yes.
he was concerned the jury in the jury deliberation room was hearing what was said at the sidebar.
Yes.
Now, I don't know that I've ever experienced that as a trial judge, to tell the lawyers at the sidebar to keep their voice down when the jury is not even in the courtroom.
But he said the same thing, right? He said, I'm guilty of that as well. We all need to keep our voices down. So it was a contentious trial. There's no way to get around that.
And didn't defense counsel kind of, it was like one of these things, almost like a zinger, like watch this, and you ask this question that clearly is out of bounds based upon the way the evidence had gone, the way the objections had gone. It was almost like, you know, here comes the kitchen sink. Let me ask this question. Would you agree or not?
I don't think he intentionally did it, but I can't answer that for sure, but I come back to Johnson. The judge must above all be neutral, and that neutrality should be of the tough variety that will not bend or break under stress. So whatever stress is going on in this trial.
And this one incident over a 4 or 5 day trial was enough for the judge to lose his neutrality?
Yes. Well, again, in Johnson, the court found fundamental error. This is preserved left and right. All he had to do was give the curative instruction. But again, if you don't give that curative instruction, what is the jury thinking? So this is a close case. Charged second-degree murder, jury came back with a lesser. This is a case involving a single eyewitness where defense counsel argued that that eyewitness was not credible. There's no DNA that connects my client to either of the weapons. The defense was that the other person is the shooter, not Mr. Breed. So this is a close case. And in a close case, anything that can tip the scales in favor of the prosecution renders the trial unfair, which is why this court found in Johnson it's a due process violation. So it's the state's burden, of course. They have to prove the error in this case was harmless. They simply can't do it in this case just from all those factors. Even if the discussion had maybe been just a couple of minutes and then we're coming back, I sustain the objection that I already objected to, defense counsel move on, but to have this break in the action for 15 minutes.
Would your argument along that line be better? I'm not judging the quality of what you're saying right now. You're obviously a very talented advocate here. But if he was convicted as charged as opposed to a lesser, does that strengthen your argument that he was, or does that weaken your argument that he was convicted of the lesser as opposed to the judge yells this out and they come back and they convict him of as charged?
I mean, it goes either way, right? I mean, I could say, of course, the standard for harmless error.
You're going to say, no, it doesn't. That's why,
Right, I mean,
I get that. But
it's not overwhelming evidence, so I submit there's not overwhelming evidence anyways, and, you know, so that's not the standard. But the way I would spin it is, look, the jury was already struggling with this case, so much so that they didn't convict him as charged, but yet if they went back to the jury room and they thought to themselves, this judge, you know, was really disliking defense counsel, so much so that the judge himself yelled objection at defense counsel, and they went and talked for 15, 20 minutes about it and came back, and all we know is defense counsel continued on. So something's going on here. We don't think that the state's proven their case beyond a reasonable doubt, but at the same time, this judge is kind of influencing me to think that because of defense counsel, you know, something's wrong. And, you know, and I will point out, the judge said in the midst of all this, I'm not going to give the curative now, but I'll give something in the final instructions. Obviously, the instruction the judge gave was instruction 3.11, which is the standard instruction. But even that didn't go to the issue. The standard instruction on page 1022, please disregard anything I may have said or done that made you think I preferred one verdict or another. The only way that if...
Or one side over the other in the presentation of testimony or evidence. Isn't that how the whole instruction goes?
No, it stops.
You didn't read the whole thing?
No, page 1022. Please disregard anything I may have said or done that made you think I preferred one verdict over another. If it had said, or one party over another, then I'd still be saying that many moments after the fact it wasn't enough, but that doesn't go to what defense counsel was asking for the curative is, I misspoke, so that's never told to the jury, and I, as the judge, am neutral and I don't favor either party. So whether or not they heard that he favored one verdict or another, they're still thinking he clearly disliked this defense attorney, and if that had any role in them reaching their verdict, then the state can't meet its burden under de Guilio to establish harmless error.
So, I mean, the judge's explanation of all this, I mean, I think he was, again, why he was trying to backtrack as opposed to just giving the curative instruction is a little puzzling to me. But his explanation was basically, I saw the prosecutor rise, and at the time the prosecutor's rising, he or she was about to say the objection, and I said objection instead of sustain because I knew I was going to sustain the objection that was being made. So he's trying to say this was a simultaneous event, and therefore, I mean, I know it doesn't read that way, but in slight defense of the trial judge, the court reporter has to put something down, and maybe she could have said they both rose together simultaneously, but at, day 4, day 5, I'm not sure the court reporter should be tasked with, putting on the record the timing of events as opposed to just what everybody's saying. But go ahead.
But it's still error, right? I mean, and it was, we wouldn't be here if the judge would have given the curative instruction.
That's what I was going to ask you. If he actually gave the curative instruction, we'd be talking about your second issue, I guess.
And I'm not going to raise that or argue that today.
No, I know. I mean, it's preserved. I mean, you raised your argument. Obviously, you have.
I cited the
you got
case.
20 minutes, and you pick and choose what's your best argument. I get that.
And I cited a federal case on my second claim that clearly rejects, and I'm the one that found that, and I, told the court it's an issue that defense counsel was arguing with the judge throughout the trial. But no, that's not a strong claim. Again, I don't have any authority that supports that claim. But this, I mean, come on, we wouldn't be here.
The judge had a reason for not giving the curative, right? He didn't want to continue to ring the bell.
That's, again...
Is there no other judge in the state that would have similarly?
Because I'm not aware, this court may have seen a record along those lines, but that's a defense attorney response. Every time I've seen that, it's the judge giving the defense attorney the option and the defense attorney saying, nah, I'd rather not focus on that anymore, or I'd rather not further ring that bell. But this bell was being rung for minute, up to 16, 20 minutes. And the defense counsel's only request from the get-go was just give the curative instruction. So again, we just can't have faith that this didn't impact even just one juror in this case. And if it did, then give my client a fair trial, start over, and let's not have a judge that's admonishing a defense attorney, whether, I'm not saying it's intentional, but once the mistake was made, and again, it's not as mild as just, I spoke too quickly. I mean, he yelled objection. There's no dispute in this record how loudly and how passionately the judge said to the defense attorney, objection.
Mr. Hufferman, you're in your rebuttal time. I don't know if you want to hold on.
Well, let me ask. And basically, we're looking at the record. The judge really didn't know that the prosecutor was going to stand up and say objection. He just presumed that because it was apparent to him it was an objectionable comment here.
Correct.
And I'm not saying that the prosecutor then took the bait and said, well, yeah, I do object.
But
and then,
that's objecting yourself in this case. Yeah. And you really got to call balls and strikes. Yeah. You can't be the one that inserts yourself into the game. And so I'll reserve the rest of my time for rebuttal. Thank you.
All right. Morning.
Good morning. May it please the court, my name is Miranda Butson, and I'm here this morning on behalf of the appellee, the state of Florida. Appellant is asking this court essentially to substitute its judgment for that of the trial court on a matter that was well within its discretion. To do that,
you do think it's wrong for the trial judge to make objections for the state, right? That's not something that trial judges should be doing.
I would agree that it's wrong for the trial court to make objections. I would
Which is what
disagree that
happened.
the trial court made an objection here. I think
the trial judge said objection. I mean, I know the trial judge then backtracks and say I misspoke, and I don't doubt that the trial judge understood that he misspoke there, but I mean, I've sat on felony dockets for 7 to 8 years, and I was a trial judge. It's just, I'll be kind here since I just was in a professionalism seminar last week. you know, I don't get the hesitancy, and maybe you can explain it or just say, hey, you know, I went there. But why not just give that instruction, the curative instruction, saying, I'm sorry, I misspoke. I anticipated the objection, and I'm going to sustain it. And certainly the judge doesn't have to ask for the defense counsel to respond because there's no speaking objections. Theoretically, it happens all the time, but there shouldn't be. You know, it's kind of. And you can't have a more empathetic person than me in the midst of trials with tiring cases and death penalty cases or murder cases. But, you know, it's just, this is a head scratcher to me. And I know the standard, you know, I heard Judge Harris, the standard, no human being in the universe would have done, or something like that. What did you say? Oh, no other reasonable judge in Florida would have done what the judge did here, not grant a curative instruction. That's the abuse of discretion standard that you're going to, you know, hang on with a death grip. No,
I
that's
will,
bad
yes.
pun. With, you know, with a you know,
because it is the
strong
standard.
grip there.
Your Honor, you ask a reasonable question, a logical question about
Compound question. Go ahead.
about why not. Well, to your original question, why not? Reasonable question, not the question before the court today. You know, counsel wants to say it seems that he's doing this for improper reasons. And
I don't know that he did it for, I forget he did it improperly. Let's give him the benefit of the doubt, which again, you know, the burn's on the appellant here to prove reversible error. But, so he misspoke. I mean, he anticipated the objection and he was going to sustain it right away because, as he explained, this was, I can't believe somebody would make that argument and it was improper argument, so I sustain it. And if he just said sustain, if he sent it, you know, half second after the objection was made, then I think Mr. Efferman said, you know, we'd be talking about issue 2 here today.
Well, even defense counsel admits during the trial that the judge spoke contemporaneous with the prosecutor. The judge, when he initially says that I did misspeak and I didn't mean to say objection, I meant to say sustained, I immediately corrected myself, this very relatable human moment, although maybe Your Honor would not have made that mistake. But
well, everybody's human, I understand that,
right.
but when you make a mistake, when judges make mistake, they should own the mistake to correct it, because at the end of the day, you've impacted a lot of people. You have people who come in from the public who sit on the jury for 5 days, and you know, Mr. Efferman's asking that this be done over, so it's going to impact more citizens in Duval County if it's reversed and sent back. You know, so the judge, this isn't the judge's first trial. So, you know, at some point you have to be a little reflective and you have to be impartial and you have to be above it as the judge and say, hey, geez, what the heck was I thinking? Let me unwind this problem, because up until that time, there was not something that was problematic vis-a-vis that there was not an impartial, it was an impartial trial. It hasn't been raised, that Mr. Efferman hasn't said, and he certainly has the ability to raise these things. He's a very talented appellate lawyer, saying, you know, hey, this was just a problem all the way through from the get-go. He hadn't said that. He's saying this at this point, and I get it. The argument is, well, that's one time, so does this one time undo all the good work of the trial leading up to that point? I get all that, but I mean, I'm rarely baffled, or maybe I'm baffled more often than I admit, that why this was a hesitancy of a trial judge to simply admit the mea culpa and say, hey, let me fix this, let me make it clear to the jury that I don't pick sides.
In a light most favorable to the trial judge, which is not the standard here, at best it seems to me like it was reflexive, like it was a reflex. Unfortunately, it came from the person who was sitting up in front of the courtroom and leading everybody through the jury trial process. And the judge then admitted that he made a mistake. So, I mean, he admitted very clearly, however you want to phrase it, I made a mistake, at least to the lawyers.
right, in saying the wrong word, I guess I would not agree that he made an objection and inserted himself into the trial as a participant.
Well, where in civil procedure or criminal procedure does it say the judge reserves the right to make an objection? I mean, you have granted, sustained, overruled, and denied. Those are 4 words that I believe judges, you know, they're not giving their opinion, they're making a ruling, but objection is not a word that normally comes from the judge.
I would absolutely agree with that. I think what we do have to...
It was error.
Pardon?
You agree it was error for the judge to for
misspeak.
whatever reason, to get up and say, I object to the defense counsel's argument. I mean, I know he didn't use the word I, but he objected to the defense counsel's argument.
He said the word objection, sure. And I think he agrees that that is
I'll
an
rephrase.
error.
He said the word objection. I agree with you.
Okay. I think what we have to remember here is going back to that standard, which I will continue to remind you of. The trial court had the superior vantage point here, and we can't ignore that. We can't ignore the fact that, as Your Honors mentioned, it's near to impossible for the court reporter to capture everything that happens in real time. Here we had simultaneous speech. The trial judge says that multiple people were speaking at the same time. We have tone of voice. He admits that he spoke louder than he normally would, but to say that he spoke passionately, he never made that part of the record.
Loudly.
Loudly.
He spoke loudly.
He spoke loudly, but
But what does that convey to the jury? That the judge is upset with the defense?
perhaps, but the trial judge was able to see the reaction of the jury, and he took them to sidebar
I said
quickly.
this to you. You wouldn't think that was bothering you, that I was a little upset? I'm not upset. I'm just saying, for example. Yeah,
I know you're not upset,
No,
right?
I'm not upset. I'm
And so the
I mean, that's
trial judge was able to see the reaction of everyone in the courtroom, and he knows exactly how it sounded. And with that superior vantage point, he made a decision. He did have a reason for doing it, and it is one that is within his discretion. Per the Supreme Court of Florida, they have said it is permissible for a trial court to use its discretion to not give a curative when they are worried that they will draw more attention to
But
the
it's
mistake.
the defendant who would be the one that would be affected, and the defendant is the one that's asking for it. It's one thing if the state says, Judge, give a curative instruction, the defense counsel says, no, we've already beat the dead horse enough, we don't want to talk about this anymore, I don't want you to do it, I'll take my chances with Ufferman on appeal. It's the defendant who inure to the benefit to say, I would like a curative instruction just so we can get back on the straight and narrow on the same page. Please do that. And for some reason, again, I'm baffled, I guess, continuously this morning, he doubles down and says, no, I'm not going to do that because let me explain to you why this all happened and how it all happened, and that's going to be good enough for everybody. He didn't say it like that, but I mean, he's basically said, I'm going to explain it, and you don't get a curative instruction because it's going to bring too much attention to it. Well, what if the defense counsel wants it to, saying, you know, Judge, please bring it to attention. I want it to be clear that you're not mad at me or you're not favoring the state, or the tone by the judge's own admission was a loud tone, which theoretically, if we were now proceeding, the jury's hearing a loud tone, just like you and they out in the audience startled when I raised my voice. I mean, why? And why? You know, some of us write opinions for different reasons about stuff. Some like to talk about supremacy of the text for reasons that I guess you should talk to the supremacy of the text people. Some other ones like to write opinions for, you know, as a learning process for people to say, hey, at some point these things happen, and this is what we should remember to do if this ever happens again to any judge in Florida. I tend to be in the latter group there. Well, I'm certainly not in the former group, I'll say that. But I'm in the latter group. Why isn't this? And I'm hearing that this judge has been reflexive throughout the course of this trial. You know, and I guess the judges have their own style, but why isn't this a teaching moment? Maybe a costly teaching moment, but at the end of the day, you know, if I'm sitting as a defendant and here's the judge making objections for my opponent, that doesn't seem to sit well in the whole jurisprudence of Florida and the country, that it should be a fair and impartial thing, that if the state beats me, the state beats me, but the judge ought not to be helping, right? You can't disagree with that comment, right? That it ought to be fair, right?
It ought to be fair.
There
Of
you
course
go.
it ought to be fair. I just disagree that we can tell from a cold record whether the jury took it as the judge objecting or the judge misspeaking. The judge thought it was clear that he misspoke. He made it very clear in the record that he thinks it's clear he misspoke, not that he objected. And I'd like to distinguish this from
So
the
his
case.
premonition of things, he's convinced that the jury didn't understand that I was picking sides, I was just misspeaking because of the jurors' vast experience and trials they've had before that?
Well, so if I said to you, objection, sustained, would it be clear that I realized I said the wrong word because of facial expressions? We just don't know what happened below. We have only the words on the page. The word no itself could be said to mean no emphatically, no, question mark, a very sarcastic no that I won't demonstrate, right? We can't tell. The judge
Well, the
has
judge
discretion.
said I said it softly, then maybe we could, from that, we could take, and we'd have to accept, I mean, absent there be something else, because we're obviously not there. We could say, well, then maybe the jury wasn't there, but if the judge admits he was very loud in his objection, or, all right, I'll take the word very out if we're going to parse. He's loud in his objection that he's making apparently on behalf of the state.
I don't
He's
think
not
he made
objecting
an
on
objection on behalf of the
All
state.
right, you're going to go.
And that's where I would distinguish this from the Johnson case that counsel brings up. In Johnson, you had a judge asking questions. You had a judge suggesting answers that witnesses adopted.
I think that's bad, right?
I do.
Okay, there we go.
I would agree, of
Just
course,
wanna
with
see
this
where the
court on
lines
that.
are being drawn.
But that is a very clear case of a judge inserting itself. You know, some of the other cases that appellant relies on had a judge jumping in and asking questions when it suspected that the state was missing elements in an offense, things like that. This one word, this one instance over a multi-day trial does not amount to the trial judge becoming a participant and jumping in on behalf of the state. And I would also point out that the instruction that appellant's trial counsel requested was actually the standard instruction, and it was given, just not when he wanted it. As you've already discussed, the trial court did, and on page 941, appellant's counsel says, there's this instruction that you give, I just want you to give it now. And the judge says that he's not going to do it right now, but he's going to do it later. And I emphasized that during the instructions after closing arguments. And so that instruction was given. So the harm here was remedied by the fact that the trial court did eventually give the exact instruction that appellant's counsel had asked for.
So, I mean, I grant you your timing's a little bit better. What if this was during the opening statement 4 days earlier and the judge denied it, he didn't do a curative instruction, but then, you know, that Friday afternoon of the trial, so he reads, what is it, 3.11, and says, you know, ignore anything I said because, you know, the evidence, look the evidence, not what the attorneys say. I say I don't favor any side. And
I would agree that the timing here is helpful.
for you.
For us.
Yeah.
I would disagree that it would have made it an abuse of the trial court's discretion just based on the
How
timing.
many times does a judge have to object before it's, on behalf of the state, before it's an abuse of discretion?
I doubt that a trial judge would ever misspeak more than once in a trial the way that the trial judge did, I would hope.
We would all hope. We all hope that these kind of things don't happen, but that's what spices our lives as appellate judges here, I guess. What do you think about his $2 cost claim?
I do think that there is an issue with the ordinance in this case.
Well, let me ask, I mean, do you even, didn't Eisnagel just write an opinion in our court here? You know, he and Judge Pratt kind of waxed eloquently about whether you have to put the actual ordinance in the thing as long as due process is aware. And this is a mandatory cost. So in other words, you don't have to the judge doesn't have to say, I fine you this, and oh, by the way, you got to pony up the $2 under that statute too. So he doesn't have to say it, and this statute is cited in the cost order, isn't it?
The incorrect statute is cited, and that's...
Isn't the correct statute, it's just the ordinance has the incorrect statute.
Oh, sorry, yes, I misunderstood, Your Honor.
But Judge Eisnagel wrote an opinion recently that basically says, as long as it's clear on the record, the lack of the citation of an ordinance, he got tired of writing cases about ordinances, so that's why we got the epistle that we got from those guys. But that's a backside story. The ordinance is incorrect, but I mean, it seems like the first DCA, Mr. Efferman's friends at the first DCA basically said as long as you cite to the statute, you're good to go. You don't have to cite to the ordinance. I mean, it seems like the ordinance itself, the language of the ordinance suggests that it's consistent to impose the $2 under 938.15. It just cites to a statute that's not apples to apples, for lack of a better word. So.
Correct. I would agree that it's lawful. It is authorized by law. I do not believe that the trial court had to verbally impose it in order for that to be a lawful cost.
But he can just cite he or she can just cite saying, I impose this. I mean, the written order. He doesn't have to say it. The written order just says, I cite to this.
Correct.
And then I guess then the argument is there an actual ordinance that's been enacted in the municipality or the county that justifies this? Because isn't that the triggering event?
Yes, Your Honor.
All right. So, all right. Want to talk about his other claim? You got the students all want to know about, you're probably the one that's most in it. What about
one that's most
about
interesting.
the polygraphs? And everybody wanders around, wonder why, how can we see polygraphs on TV and we back away from the world of polygraph, and Mr. Ufferman's argument was, hey, you guys at the Jacksonville Sheriff's Office, you guys administer polygraphs to some witnesses if you think that the witnesses you have concern about the truthfulness of the witness, and this guy here, the main witness, may have been, I guess in the defense view, a little less than forthright about things. Why didn't you administer a polygraph to him? Why can't I bring that in front of the court's attention so the jury can perhaps discredit the main witness? And the judge says, no, can't do that either. I guess that's one of those abuse of discretion things, you think?
Another abuse of discretion.
I know, you got
sir.
state of Florida lives and dies in the abuse of discretion in criminal appeal, don't it?
But in this case, I would say it's not even a close call here. If a polygraph had been administered, it would not have been admissible. So to question the detective about the sufficiency of his investigation by bringing out whether he did or did not conduct a test that would not have been able to come into court was just so highly prejudicial.
So you think that it'd lead to more confusion with the jury here?
Absolutely, wild speculation.
At one time they're wondering why the judge is objecting, then the other time why they're talking about a polygraph that's not admissible anyway, so why, yeah. That one I think I can follow that one. I'm not as baffled about that one. How about that?
Okay.
Yeah, no, it's an interesting argument that the defense counsel was certainly being zealous in his advocacy below, but
But you're saying just the mention of the word polygraph. Obviously, I believe part of the theme of the defense at trial was the insufficiency of the investigation. I think that's probably highly likely that a lot of times it's insufficiency of the investigation. But you're saying just to be able to mention the word polygraph would be prejudicial in and of itself.
Right. The rules require the trial court to prevent even, the mention of inadmissible evidence. And in this case, if this witness had been given a polygraph and had passed, and defense counsel had attacked the sufficiency of the investigation, I don't think that defense counsel would have agreed that the state could then, that they had opened the door, as in this Heard case, and that the state could have then brought in evidence that, he was administered a polygraph. I'm not going to tell you the results, but we're here in court today.
so you don't think that the prosecutor in the case in chief could have asked the investigating officer without leading the officer, saying, well, part of your investigation, did you administer a polygraph examination to the eyewitness here and he passed? You probably think that would have been objectionable and sustained.
That would absolutely have been objectionable.
Sustained after the judge heard the objection first, I guess.
In the proper order, yes.
In proper order, yes.
Yes.
In a moderate tone.
In a normal tone of voice, yes. As counsel said, he acknowledges the federal case where the federal court applied exactly the same logic that the trial court did here. So there can be no abuse of discretion because it's a reasonableness test. And here we have other reasonable.
Confuse our students. We're not bound by the federal decisions, right?
You are absolutely not. But I bring it up only because it then becomes impossible to say that no other reasonable, rational judge would have done the same thing when another.
We're going to presume those judges in 2001 are reasonable and rational, right?
I believe we should, yes.
That's an old case, too. Is that still binding?
It was a bit old. I do see I'm out of time. Because the trial court here did not abuse its discretion, the state would respectfully request the court to affirm the judgment and sentence in this case. Thank you, Your Honors.
Thank you. Mr. Ufferman, I will add on a minute for you.
Thank you. May it please the court, I don't intend to use the full
You
time.
agree that the $2, I know you didn't want to talk, but the $2 is is not something that has to be pronounced.
I agree, but the concern is that if there's not an enacting ordinance, then you cannot impose the $2. And that would be the due process issue from the Judge Eisenagel was referring to in the King case. So my argument is that this ordinance needs to be changed. It needs to reflect the correct statute. Otherwise, there's not an authorizing ordinance in Jacksonville or Duval County to allow this $2 cost. Let me get back to the first claim. 2 quick points. The first one, again, I've already pointed the court to it, but I'll come back to it. 1022, the instruction that the judge gave was simply, please disregard anything I may have said or done that made you think I preferred one verdict over another. It was not anything along the lines of preferred one party. And even if it had been said at that point, the jury was still never told that the judge misspoke and should not have objected to the argument. But as far as the judge's ultimate reason for not giving the curative instruction, and I don't see the connection, but the very last thing the judge said before the sidebar concluded and this went back to closing argument in front of the jury was this: Mr. Eiglarsh, defense counsel, that is an issue that I believe prejudices the defense. I'm asking for a curative instruction. The court is denied. The court, I'm denying it because you brought this issue up. You brought this issue up to bear by saying you knew it was improper. If you don't want to be chastised in front of the jury, don't make improper arguments in front of the jury. It's a simple solution. That's page 945. That cannot be the reason to not give a curative instruction. The defense counsel made an improper argument, but the answer is the state objects, the judge sustains it. It can't be because you made an improper argument, but then I misspoke and objected by mistake that I'm not going to give a curative instruction because you gave the improper argument. So for that reason, I'd ask this court to reverse and give my client a new and fair trial. Thank you.
Thank you.